the patent filing process. Hello everybody, in this presentation we, Origin IP Solutions at Bangalore, India, will attempt to give an overview of the patent filing process. We will touch upon the different aspects of the patenting process, namely the criteria of patentability, the important considerations before filing for a patent, the need to seek permissions for foreign filing, and the process itself of filing a patent application at national and international level. Patent filing is a complex process and needs expertise at various steps. It is therefore strictly recommended that you take professional advice. First of all, let us understand what is a patent. A patent is a Latin word meaning to lay open. It is a set of exclusive rights granted by a country to an inventor for a limited time period in exchange for detailed public disclosure of the invention. The requirements and the extent of the exclusive rights and the procedure differ widely between countries as per the national laws. So why should a business file for a patent? What can be the reasons or inherent advantages of filing for a patent? Well, depending upon business goals and strategies, the main reasons or advantages are: it helps the inventor to commercialize the invention, because if there is no protection on the idea, he cannot prevent third parties from copying it. Another reason or advantage is that the inventor can label the product as patent pending as soon as the patent application is filed. Thirdly, the disclosure of the invention becomes easy as the inventor obtains priority date upon filing a patent application, and this plays a vital role to prove that he or she is the inventor. Fourth, for entrepreneurs and startups who want to base their business on new ideas, a patent plays a very important role in obtaining funding from angel investors or venture capitalists. Finally, it immensely helps in the protection and enforcement of the invention or the idea, as by means of filing a patent application, the applicant can prevent third parties from making, using, selling, offering for sale, and importing the patented product or product made of a patented process. Once the reason for filing for a patent is ascertained, there are some important considerations that need to be taken care of before you file for a patent. The first and the foremost consideration is documentation of the invention, highlighting the novel elements compared to the existing knowledge, the existing technical difficulty, and the solution proposed by you in detail. Secondly, it is important to perform a patent search or novelty search to ensure that the idea is worth proceeding further with for a patent. Even if the invention is not found to be novel by means of a patent search, prior art documents can be used to further refine the invention before proceeding with patent filing. Confidentiality of the invention. This is an important consideration. Since the invention has to be novel on the date of filing, it is essential to maintain the confidentiality of the idea till the patent application is filed. Finally, it is absolutely essential to have clarity on the countries where you will be filing for the patent, as patent filing is an expensive process. Selecting the jurisdiction carefully can actually save a good amount of time and money. Criteria for getting a patent. Before understanding the patentability criteria, we must be clear about the difference between a discovery and an invention. A discovery is finding something that already exists but which no one knew about earlier, for example, capillary action in liquids, while an invention is making a new thing which did not exist earlier using the current available knowledge, for example, the invention of a fountain pen using the capillary action of liquids. Having understood the difference, we must remember that a patent is granted for inventions and not discoveries. Furthermore, the invention must meet the following criteria before it is granted a patent. These are: novelty is the first requirement of patentability. It means that a patent cannot claim something that already exists, or that the invention should not have been anticipated by publication, claimed in any document, used in the country or elsewhere in the world, before the date of filing of patent application, and the subject matter is not in public domain, nor does it form a part of prior art. Novelty is determined before the inventive step because the creative contribution of the inventor can be assessed only by knowing the novel elements of the invention. The second requirement for getting a patent is the inventive step or non-obviousness. This is one of the most complex aspects of the patent law. It means that the invention should take technology one step ahead and should not be a replica or repetition of some previous inventions. This is to say that the invention must be non-obvious to a person skilled in that area, or in other words, some feature of the invention involves technical advance as compared to existing knowledge or has economic significance or both. The third requirement of patentability is industrial application. This means that the invention should be capable of being used commercially. Let us now get an idea about the patent filing process. Patent filing process and overview. The process of patenting starts with a new idea. Once the idea is conceived, it is important to document it. After that, the novelty of the idea needs to be determined, as novelty is an important criteria of patentability. This is done by performing a patent search. Using the results of patent search, it is a good idea to further refine or fine-tune the invention. Once this initial assessment of novelty or patentability is done, you may proceed with the filing of application to obtain a patent. To file for a patent in India, the application with the required documentation can be submitted to the Indian Patent Office. However, if you wish to file directly in a foreign country without filing in India first, you will need a foreign filing permission from the IPO. Failure to seek foreign filing permission can result in criminal liability or abandoning of Indian patent application or even revocation of the Indian patent, if any, and shall be punishable with imprisonment up to 2 years or fine or both. Foreign Filing Permission, Section 39. Section 39 is one of the important sections of the Act. It states that if the applicant is resident of India but wants to file for a patent application in foreign country, he can file an application at the Indian Patent Office and then wait 6 weeks to receive any objections, or he can take permission for foreign filing from the Controller, Indian Patent Office, by filing Form 25. Foreign filing permission is necessary to safeguard national defense and security. If the invention is found to be relevant for defense purpose or atomic energy, then permission will be contingent upon clearance from the central government. Permission will not be granted for an invention for which an application for protection has already been filed in foreign country by a person resident outside India. Patent filing, the process. As a result of novelty search, if the idea is novel and you decide to file for a patent, specifications or patent application shall be drafted. These are of two types, provisional or complete. Provisional application is often filed to claim priority date, especially when the inventor needs some more time to complete the invention. Complete application contains complete specifications of the invention and is filed directly to get a priority date. In case of provisional application, complete specification has to be filed within 12 months from the date of filing the provisional application. The date on which the patent applications, provisional or complete, are filed at the patent office is the priority date for that invention. 18 months from the date of filing an application or the priority date, the application is published on the official website of the patent office. Publication of application is a very important step, as from this date the application forms part of prior art. The application may be opposed by anyone on various grounds, such as lack of novelty, non-obviousness, industrial application, etc. This is called pre-grant opposition. After publication, examination of the application takes place and the report is sent by the examiner that needs to be replied to within the given time period. The reply to the report needs to be sent to the controller. Once the report and objections raised are cleared, the applicant will be granted the patent. Once granted, the applicant will have to pay annual renewal fee to maintain the patent. The grant of patent is published and thereafter it may be opposed by an interested person on various grounds such as lack of novelty, non-obviousness, etc. This is called post-grant opposition. After 12 months from the date of grant, a granted patent may be invalidated by means of revocation. International filing of the patent. We know that in order to file for a patent in any foreign country, we either need to file in India first and get a priority date, or obtain permission from the patent office in case of direct foreign filing. Once this is done, one may proceed with the international filing. International filing can be done through two routes. The PCT application route. This application is filed through the PCT or the Patent Cooperation Treaty, which is a filing platform and enables you to file an application in multiple countries within 30 or 31 months from the priority date. The second method is the non-PCT or convention application route. When the application is filed directly in the country which is a member of the Paris Convention, it is called the convention application. For example, if you file in India and then directly file in USPTO, the application filed in USPTO is called as a convention application. Once the application has been filed through either of the routes, it is processed as per the laws of that country. The idea of this presentation is to give a brief overview of the process of filing for patents in India and abroad. Since the process is complex, it needs expertise at various steps. It is therefore strictly recommended that you take professional advice. About us. Origin IP Solutions is a Bangalore-based IP firm offering services in the area of patent, copyright, trademark, design, and contract law. We provide end-to-end solutions and services to the clients by assisting them with identification, analysis, protection, management, and exploitation of IP in an effective manner. Our mission is to enable our clients to realize long-term value and benefits from IP by identifying, securing, exploiting, and managing it in the best possible manner. Contribute to the society and nation by making the industry and academia aware about the legal provisions and concepts of IPR in a simplified manner, thereby enabling them to secure, exploit, and manage it effectively. For more information, feel free to contact us over phone, email, or look up our website for latest information. Thank you.